Today in the episode of Justice Talks, we have with us a special guest, International Co-Prosecutor Mr. Nicholas Koumjian. He worked as a prosecutor in Los Angeles for 20 years. For the past 19 years, he has been working in international criminal courts in different countries. Currently, he is International Co-Prosecutor at ECCC. Prior to his appointment here, he was Senior Appeals Counsel for the prosecution for former President of Liberia, Charles Taylor, at the Special Court for Sierra Leone. He has also represented Abdallah Banda and Saleh Jerbo before International Criminal Court in case involving the situation in Darfur. He has also assisted victims from the Ivory Coast on a pro bono basis. He was principal trial attorney for the trials of Charles Taylor, headed the UN-funded Serious Crimes Unit in East Timor, and finally he was also trial attorney at the International Criminal Tribunal for former Yugoslavia and State Court of Bosnia and Herzegovina. Thank you, Mr. Nicholas Koumjian, for joining us today.
Thanks.
It's a pleasure to have you with us. So today's Justice Talk is about international courts and ad hoc tribunals, and in any way they have helped in the post-conflict transitions. So we're going to divide this interview into three segments. The first segment is going to be about your work in the Khmer Rouge trials. The second segment is going to be about other justice mechanisms. And third segment is about, it's a fun round, and we want to know as a person, as a prosecutor, and we want to know what you do in your day-to-day life.
Sure.
So moving on with the first question, can you tell us about the complex structure of ECCC?
Well, the extraordinary chambers of the courts in Cambodia, the ECCC, was set up by a treaty between the United Nations and the government of Cambodia. The royal government of Cambodia, back in the 1990s, requested United Nations assistance in establishing a mechanism to hold individuals accountable for the atrocities of the Khmer Rouge period. There was a lot of international pressure at the time to see some mechanism to hold at least the leaders responsible for what occurred at that time. The negotiations were complex for a variety of reasons. There was still a civil war ongoing until 1998, but eventually an agreement was made. Part of the agreement, part of the issues that were much debated in the negotiations was exactly how much control the Cambodian justice system would have, or Cambodian judges, and how much would be under international personnel's control. The mechanism that was finally agreed on was to have a majority of Cambodian judges in each chamber of the court, with the provision that decisions require a supermajority. So any decision would require at least a mix of international and national judges, at least some mix. So that's rather complicated, and especially when you get to the issues of what happens when there isn't a supermajority. But the court has been up and running since 2006. Originally, it was envisioned as a 3 or 4 year project, which whoever had that prognosis really didn't understand the complexities of international criminal law and how difficult it is, especially to build cases against top leaders, how complex the investigation is, the trial phase, pre-trial phase, appellate phase. It was obviously very naive to think it could be done in 3 or 4 years. Certainly no one then thought it would still be around now, 12 years later. But that is where we are at. And the court has completed, depending on how you count them, 2 or 3 trials. The trial of the commandant of the security center here in Phnom Penh, S21, Doi. He was tried. He basically admitted his role in the camp and his role in tortures and killings in the camp. Subsequently, the top surviving leaders were put on trial. Originally 4 individuals, and that was Nunchea Q Sampan, who was the head of state. Nunchea was number 2 in the regime. The former foreign minister Ing Sari and his wife Ing Tari, who was Minister of Social Affairs during the Khmer Rouge period. Ieng Sary was found not competent before the trial began because of an Alzheimer's-like degenerative mental disease. And Ieng Sary died during the first phase of the trial. The judges, due to the advanced age of the accused and the very massive indictment against them, covering what happened over almost 4 years in the entire country and a variety of charges, decided to sever the case. They thought there would be little chance of completing all the charges, so they decided to first do a series of trials, and the first one would cover crimes associated with the evacuation of Phnom Penh in April 1975, and a subsequent transfer of the population, generally from rural areas towards the northwest rural area that began later that year. And ultimately, in the middle of the trial, they added one massacre of the soldiers of the former regime at Tulpotre. So that case became known as Case 2/1. There was a verdict, the accused were convicted, they've been sentenced to life in prison, and that has been upheld on appeal. But a decision was made that it was very important to proceed on the remaining charges. And I remember I spoke to victim groups about this, civil parties, and they pretty unanimously told me they thought it was important for the second trial to go forward, because the charges that remained were most of what happened affected most people. So the charges that remained that we tried in the second case included the enslavement of the population at work sites and cooperatives. This happened, of course, around the country, arguably pretty much everywhere. People were denied fundamental freedoms, and the regime exercised the power of ownership over individuals, a definition of enslavement in international law. But of course, when you're doing a case like this, you can't put on evidence of the experiences of all 8 million people. So certain sites were chosen for each of the legal charges. So there were certain cooperatives and work sites were chosen. Security centers were chosen, 4 of them, including S21, which I mentioned, the security center here in Phnom Penh, where the records that survive and have been recovered would indicate that about 18,000 individuals lost their lives. That second trial also covered forced marriage. That's something that wasn't much talked about before the ECCC started doing its cases. And it was, frankly, some very brave survivors of the forced marriage and some NGOs that were advocating for them, civil party lawyers also, who pushed to bring that to the attention of the prosecution and the investigating judges. And so the indictment in Case 2 against the top leaders included these charges of forced marriage and charges of forcing the couples to then consummate the marriage, which we classify as, we call rape. It's charged as another inhumane act, so rising to the level of other violations of other inhumane acts as a crime against humanity. So these still remained and were part of Case 2. Also, Case 2 included charges of genocide against 2 ethnic minorities. The biggest crimes in our case, of course, was the regime's targeting of its suspected political enemies, and most of those, of course, were Khmer people, Cambodian people, who were seen as potential political enemies for whatever reason, because of who their parents were, being teachers or former soldiers of the former regime, or once the Khmer Rouge started splitting with internal suspicions, anyone from certain areas of the country was under suspicion, and thousands killed. So the exterminations of the political enemies was the charge that definitely involved the most amount of killings. The genocide is a crime that's a little different. It requires that the intent be, it doesn't cover the protection of a large number of individuals, it's the protection of the group. Genocide is when acts are done, including killings, with the intent to destroy a national, racial, ethnic, or religious group as such. So while we weren't saying that the Cambodian Khmer Rouge leadership tried to kill all Cambodians or all ethnic Cambodians, the evidence in the case showed that during the regime, the latter years of the regime certainly, a decision was made to kill all the ethnic Vietnamese who remained in the country. And a decision further was made, and policies carried that out, to destroy the Chan as a religious and ethnic group. These are a group that's Muslim generally, and most of their origins from the Malaysian peninsula. Had their own language and traditions, and made them very important to them, the practice of Islam. The Khmer Rouge regime took all of that away and targeted in particular those areas where the Chan were most concentrated, and we had evidence that orders were given to list all the Chan and kill all of the Chan in those areas, in those districts and sectors. So all of this, these very important charges remained in case 2. And that is what we completed that trial. We actually completed the evidence 2 years ago. The judges in November, a few months ago, came out with an oral ruling, a summary convicting the accused of most of the charges, and we're awaiting, and we expect to receive very soon, the full written reasoned judgment, which I understand will be at least a couple thousand pages. There still will be an appeal phase for that.
Thank you so much for your brief answer. We also understand that these are passive trials. It involves a lot of victims and civil parties. Tons of documents are involved. So as the International Court Prosecutor, you manage a team of 7 to 8 lawyers, and you have about 13 interns in your office. So what is the strategy that goes behind in preparation of such a massive trial?
Well, all of the cases that involve mass atrocities, when you're targeting the people that generally are believed to be most responsible, they are often the top generals, or even, perhaps even more often, they're political leaders. Sometimes they're even political leaders across a border in another country. That was the case, for example, in the Charles Taylor case, or the Milosevic trial, where the allegations were not that Milosevic was in Bosnia. He was the president of Yugoslavia at the time. Charles Taylor was the president of Liberia, but charged with crimes in Sierra Leone. But even in our cases, for example, in Munchea, the number 2 in the regime, in Koumjian, most of the crimes that happened in villages, there are thousands and thousands of villages, work sites, and cooperatives where people suffered from the policy of the regime. Many of these villages, the accused have never visited. Certainly, most of the victims never met Munchea and Koumjian. Munchea and Koumjian wouldn't know them, and probably didn't know the direct perpetrator, the person that forced them to marry, that tortured them, that killed their husband, wife, or child. So the challenge always in these top cases, it's complicated, is to show why the actions of the accused persons at the top of this leadership structure, how those actions contributed to crimes in places often that they'd never been, against victims they didn't know, often committed by direct perpetrators who never had any direct contact with the accused or a direct order from the accused. So this is true of going back to the Second World War in those cases. This is a very complicated process to show how these policies existed around the country, how the actions of the accused contributed to criminal policies, how these criminal policies resulted in the concrete suffering of the victims of the crimes. And it's complicated. So in the ECCC, on the case file, the evidence that's admitted in case 2 is certainly over 200,000 pages. The victims who came to testify, it's difficult to select a group that's representative. You obviously can't call everybody. There are thousands and thousands of, hundreds, millions of victims, really. So we called, I think, about 250 witnesses in case 2. If you put the 2 trials together, the evidence took close to 4 years. So these are complicated because you're trying to show what happened over a great, in this case, 4-year period of time, and happened in so many places to so many people, and the chain of events where these policies of the leaders led on the ground to the crimes against the victims.
Thank you so much. We also understand that you come from a common law system. You were prosecutor in Los Angeles for 20 years. And now you have to sometimes argue in front of judges who come from civil law system. So do you have faced any kind of disapproval from any of the judges for being a strong prosecutor or putting victims and civil parties or prosecution case in a strong manner forward?
No, I don't think I've ever felt that I was discriminated against, or that judges from civil law countries did not appreciate a prosecutor being forceful in their advocacy. Of course, it's very important, and I hope the judges have the impression of me that a prosecutor be fair. The prosecutor has a unique role. You don't have the client that you're representing, but you're really seeking justice. So it's very important for the prosecutor to, for example, make sure that all of the evidence, including that's not favorable to his case, is available to the defense, not hidden from the judges. That said, of course, you do have an opinion on a case, and it's important to put that forward. Each system is a little different. So, of course, there are some frustrations where I would wish that the system in my home country was used more. Sometimes it's just the opposite, and I appreciate more the way the international courts use the evidence. But even among the international courts, everyone, the rules of procedures are a little different. So any good advocate, any good lawyer, and any good judge in international criminal law has to be open to the fact that you're not trying the case in your domestic jurisdiction. The rules aren't going to be identical to what you were used to in your previous domestic career, and they should be adjusted to the appropriate procedures for these international courts.
Thank you so much. How about you think about the structure of the court? It's very complex. You have so many departments, starting from the OCIJ, Office of Co-Investigating Judges, to pre-trial chamber, then to trial chamber and Supreme Court chamber. Do you think it is a complex court system? How it is different from other court systems that you have worked in?
Well, the court system of the ECCC mirrors intentionally. It's the extraordinary chambers in the courts of Cambodia. So it mirrors the structure of the Cambodian courts, with the possible exception of the pre-trial chamber being somewhat of a hybrid between the Cambodian system and the international system, or a unique institution. Of course, it's an investigative judge system. None of the other international courts that I worked in had that. So in an investigative judge system, like they have in Cambodia, like they have in France and many other continental countries, some other continental countries, the judge is primarily in charge of the investigation. As a prosecutor, that's a little frustrating. We don't get to frame the charges the way we would want to frame them. We can't pick up a phone and call a witness or an expert and have that evidence necessarily admitted. We have to request that the judges do that. So it's different. Now, how does that work in these massive cases? I think Some people had the hope, and maybe some people still are of the view, that that type of investigative judge system is generally civil law. Countries are generally more lenient on rules of evidence, such as hearsay, for example, that system would be appropriate for these cases. I would say I probably do not agree that the system has been appropriate or has particularly advanced the efficiency of doing those cases here in Cambodia, and is the best for these kinds of mass crimes. I think part of the reason for that is in this investigative judge system, from talking to lawyers who practice more in it, my understanding is typically that it results in a longer investigation because the judges are carrying it out. It's often sometimes with the involvement of parties, including the defense sometimes. But then it's a much shorter trial because the judges at the trial level often place more reliance on the evidence that was developed at the investigative stage because it was collected by this neutral body, and trials are much shorter. In the ECCC, I think what we have is we've sort of taken the long investigation, but then we've had the typical international trial, more adversarial, with all of the evidence challenged by all parties. So we sort of resulted in a long investigation and a long trial. And I don't think it's been the system that probably could have resolved the cases in the most efficient manner.
Thank you for explaining the trial so well. So moving on to segment 2 now, we want to understand about the new justice mechanisms that are coming up in the international domain, especially about missions such as fact-finding mission in Syria and Myanmar. So what do you think about those kind of things coming up, and how do you think it's going to contribute in providing justice to the people of those countries?
Well, for crimes that have happened since 2002, when the ICC started operation, the international environment is quite different. So we have this court now that's set up by treaty. I believe there's 190, 200 or so countries that are members of the International Criminal Court. However, many important countries, big countries, and particularly powerful countries, are not members of the court. Many of the countries where conflicts and atrocities are taking place are not members of the court. So I think if you go by the countries with the largest population, from China, the United States, India, Pakistan, Indonesia, none of those countries are members of the International Criminal Court. So that's a problem. And Myanmar, for example, is not a member of the International Criminal Court. Syria is not a member. How do you deal with those situations? There's been somewhat, I think, of a pushback against international criminal courts because of the criticism that, these courts take so long and they're expensive. And in the case of these ad hoc tribunals, generally set up in The Hague or set up outside the country where the atrocities happened, some felt it was too far removed from the victims, or that there was countries that were involved were giving up too much sovereignty by having international bodies prosecute these cases. So obviously I think that's clearly the view of the governments. Kind of expect, you wouldn't be surprised by that, in Syria and Myanmar. And so there's really a challenge of what international community concerned about atrocities in those places can do to see that there's, we hope, even-handed justice. So there's more and more, I think, of a trend rather than seeking to set up an international mechanism where the judges and lawyers are foreigners, which I think has certain advantages as far as being removed from the politics of the domestic country, hopefully. There's more of a pushback to have the trials done by domestic actors. Sometimes people are pushing for more regional courts, regional actors. And that is the recent trend. So we see that the United Nations has set up mechanisms for investigations of the crimes in Syria, for the crimes of ISIS in Iraq, and now for crimes in Myanmar, with the idea that an international body associated with the United Nations would help collect the evidence in a manner that would be conducive to holding those people most responsible, those leaders and others most responsible to account for these crimes, and then making that available to courts for domestic prosecutions, whether that's in the country or sometimes a country that perpetrator is just passing through, perhaps would make an arrest of a ISIS suspect, for example, could be arrested in Europe or something, and then the evidence would be made available. Now, this is a trend that clearly is growing. We'll have to see. Often trends, they can grow or they can lose their flavor of the day reputation if they're not successful. So we'll see what happens with those courts. But definitely that is the way, in general, international law is moving towards now, more of international assistance for domestic prosecutions.
Thank you so much. Moving on to our next question. I want to know about how do you respond to the criticism of International Criminal Court and these kind of ad hoc tribunals, because countries such as France, Germany, USA, UK, they are investing in wars throughout the world, but at the same time they have also contributed a substantial amount of money in peacemaking process through these courts. But the difference is huge, what they have invested in the peacemaking process and how much they have invested in war. So I see a double standard there. And how do you respond to these kind of criticism?
Well, certainly I understand people that believe that the cases take a long time. They'd like to see more efficient. And I really think we need to continue to look at ways we can make the trials more efficient, both occur quicker and cost less money. That being said, you're never going to have these trials be as short as a domestic murder trial because they're so complicated and so many people are involved. Thousands of, or sometimes hundreds of thousands of individual crimes are covered by the cases. Justice can be expensive. For example, in the United States, there was a terrorist bombing of the Oklahoma City Federal Building where I believe about 200 people were killed, including many children. The cost of that trial, I read at one point, was $100 million for that case. And that's one incident in one place in one day. The kinds of cases that we're doing, for example, case 2 here at this court, it involved what happened over 3 years and almost 9 months. It happened around the country in thousands of villages. And the number of victims was really 8 million. The entire population of Cambodia suffered from at least some of the crimes, the enslavement or forced marriage. So these crimes are very huge, and its justice is going to take time and cost money. Also, as you point out, war is expensive. Peacekeeping is expensive. Providing benefits to people after they've suffered these crimes is very expensive. Refugees that are traveling from places like Syria now to Europe and other places in the world cost those countries that are receiving, especially those that are generous, money to help these people survive humanitarian assistance and reestablish their lives. So all of this is very expensive. If we can do something to prevent the crimes from happening, that obviously is preferable. Peacekeeping forces, putting military in a country to enforce a peace, costs hundreds of millions of dollars in every situation. So it's very, very expensive. What's important about is that perhaps these cases can have some deterrent effect. I'm certainly not so naive that I think because we've had international criminal law cases in the last 25 years, crimes are going to stop. There won't be any more atrocities. But I do believe that atrocities probably have been prevented. I see even in the most advanced countries, you see them going to great extent to have lawyers approve targeting, have lawyers sometimes get involved about whether or not providing military assistance to a country is legal or not because of indications that that country is involved in crimes against humanity or human rights violations. It's become part of the conversation partly because of these cases that we do. You know, if we didn't prosecute murders in Los Angeles or New Delhi, or if we did not prosecute rapes in Los Angeles or New Delhi, I think we all would expect, even though we prosecute and still rapes and murders happen, that some were prevented. Some more would happen if there was complete impunity for those who perpetrate these crimes. And I think the same is true of international criminal law cases. They provide some deterrent effect in addition to providing the victims some sense that they live in a more just society.
Thank you so much, Nick. So moving on to our final round, final segment. This is more about a fun round. So this round is called Know Your Prosecutor.
Good.
So we conducted a survey within Berkeley Law and people wanted to ask you certain questions.
Okay.
And so my first question is, what do you do in your free time?
Well, here in Cambodia, I like to swim. It's always good weather for that, and there's some nice facilities, so I enjoy that very much.
And which book do you reading right now?
Well, I think I just recently finished a book, and it was about the policy making in the war in Afghanistan.
So what is your favorite cuisine and food while staying in Cambodia? What do you enjoy? How do you spend your leisure time?
Well, that's hard because I like so many different kinds of food, and probably my favorite changes month to month. Enjoy the variety. And one of the things we're fortunate here in Phnom Penh is there's a lot of different types of ethnic cuisine that pop up all the time, and quite good. So it's very hard to pick which one is my favorite. I enjoy Japanese food, I guess, at the moment.
So like now Khmer Rouge trials are coming to an end. So where do you see yourself 5 years from now?
Yeah, this is a difficult question and one that I think about quite a bit. I don't know. These international courts are shrinking the number that are going on. The United States, of course, is not a member of the International Criminal Court, which makes some complications for Americans in some positions there being hired. And I've been doing it for the last 18 years. I don't know. I may go back to the United States. I may find something. I think it's very hard to predict what will come up in 5 years. But I also look back with a lot of fondness on having practiced domestic law in the United States. I think that was fun. I do miss the fact that in doing those cases, they would get over quick. You know, you do many cases in a year, even many trials. And I wonder if I can do a jury trial again after 20 years. But I think I would like to try that.
Thank you so much.
Thanks.
And what is one piece of advice that you would want to give to young lawyers out there who want to study international criminal law? I remember reading in one of your interviews, you said international criminal law is still at the nascent stage. And we have no further ad hoc tribunals coming up. And justice system is now looking at different mechanisms to solve the cases. So what is one piece of advice for lawyers who are now studying international criminal law? How do they see their future in this field?
Well, I think definitely the number of tribunals doing trials has been on the decrease in recent years. You never know, that can suddenly reverse itself. But the trend, as we discussed earlier, is more assistance to domestic processes. And there are, I think, many jobs like that increasingly around the world. So in something like the Central African Republic, there's international assistance to courts being established to deal with atrocities. In South Sudan, there's talk of that. There are these international investigative mechanisms I mentioned. I think always there's going to be a lot of competition for these international work. often those who are willing to go to the places that are least popular, sometimes they're not as comfortable, sometimes they're a little dangerous. They're more likely to get their foot in the door. It always helps, of course, to speak languages and to just have that hunger to be involved in these cases, to feel like you're playing some role in doing something to rectify the horrible atrocities that people suffered. So I do wish your Berkeley students, it's a great university, much success, and that some of them will enter the field.
Thank you, Mr. Nicholas Koumjian, for joining us today. It was a pleasure talking to you. You were very honest about the things you said, and we wish you all the best in your future endeavors.